Hi guys, it's Kathy. I hope you're doing well. We made it to Sunday night. I hope you guys are having a nice, easy weekend before we go back to work tomorrow. So I got one courtroom today. Hopefully lots of good stuff happens in it. I'm not 100% sure. But I got to talk to you about next week. I work open and close a lot next week. So, there might be some premieres. I might make some premieres and get them uploaded because I open and close a lot next week, even up until Saturday. I'm opening and closing on Saturday. So, I mean, that's a lot of hours. Then it takes 4 hours to drive each day. So, I don't know how much I'm gonna be with you next week. I just physically I just don't know how I can do it. But I'm gonna try to get premieres ready so that we can still, talk and chat every day, even if I'm dead asleep, which I could be, or I could be in chat. Who knows? I don't know. Sleep isn't the easiest thing to get every day. You know what I mean? Even when you're exhausted, except when I have to, do a live stream, then sleep is really easy. Oh my. Yeah, this morning at 4 a.m., I was wide awake. Wide awake. I'm like, man, I should have just streamed this morning. Why aren't I streaming right now? But no, it's nice having one day off a week at 4:30 in the morning, so I can catch up on sleep if I need to. But we're gonna watch this judge today do his thing. Hopefully we haven't seen this before. He sort of looks a little familiar, doesn't he? This definitely isn't the guy from. Oh, it was the guy from last stream because I did not change my video. That's better.
This is 25.
That's a different judge. I looked at that and I was like, wow, this looks really familiar. How in the world did that happen? There we go. There we go. All right. Here we go. Put Tiffany on the case. Tiffany works too. Maybe Maiko can take over. Hey, Maiko, you got a camera? You and Bobby. We'll have Maiko on one side, Bobby on the other. Oh, that'd be so funny. All right. Let's press play. Here we go.
T7572, People State of Colorado versus John Voss.
Brady Harmon for the people.
Malika Johnston for Mr. Voss. Thank you for your patience, Judge. Mr. Voss appears out of custody to my right.
Okay, thank you, Ms. Johnston. Good morning, Mr. Voss. I know you are being pulled in about 25 different directions at once, Ms. Johnston, so we understand. All right, this matter is set for a motions hearing today.
Judge, that's a woman. That's a woman. 25 things at once, that's easy. That's why we're still sleepy.
Testimonial motions have been filed. Motion to suppress for lack of reasonable suspicion, lack of probable cause, and to suppress statements as involuntary. Are those the issues that we're litigating, Ms. Johnston?
Yes, Judge, and I think the purported Miranda waiver is involuntary, so yes.
All right, so that would come into voluntariness of statements.
Thank you.
Sure. All right, people ready to proceed?
Yes, Your Honor. People call Officer Wilkerson to the stand.
Thank you. Like a legal pad down there somewhere. If you raise your hand, do you swear or affirm under the penalty of perjury that the testimony you give before this court shall be the truth, the whole truth, and nothing but the truth? Thank you. Please be seated.
Morning.
Good morning.
Can you please state your name and spell your last for the record?
Karina Wilkerson, Wilkerson.
Where are you currently employed?
Arvada Police Department.
Were you working on November 12th of 2025? What were you doing at approximately 2 a.m. that
I
morning?
was on routine patrol in the parking lot of Home Depot.
Did you see anything that caught your attention?
Yes.
What did you see?
I had seen two vehicles, one of them being a vehicle that was parked completely crooked, not in a designated spot, and the store had been closed for several hours.
Whoa, whoa,
What did
whoa,
you do with
whoa,
that?
whoa, wait. What do you mean by completely crooked? Because, that's not a crime. I'm going to say parking crooked happens sometimes. Officer, you don't have to be so judgmental, Turning that wheel is hard.
That point.
I parked my patrol vehicle and then I got out and I started to approach both the vehicles.
And what was your purpose in approaching the vehicles at that point?
Initially, just to see why one of the vehicles was parked pretty crooked and basically do welfare checks, see what was going on, if the vehicles were possibly stolen or stuff was happening in that area.
And what did you see as you approached those vehicles?
I had seen one gentleman exit one of the vehicles, and then begin speaking with him initially.
And what did he tell you?
He had told me, his name was Andrew, he had told me he was there to help a friend who had gotten a flat tire from striking a curb.
And who was that friend?
Mr. Voss.
And after speaking with Mr. or Andrew, did you speak with Mr. Voss as well?
Yes.
And
Okay, usually when I hear crooked park job, and she would agree with me, she just would. I think of my daughter, Tiffany. My daughter, Tiffany, hates driving. And this is true because you guys see me drive her to work every day and home. Because she hates driving. Now, she has a driver's license. But she just hates it so much. It's not something that she could do every day. So, me, my daughter, and my son, we decided to take a break this morning from life. All right, we were just like, guys, we need to get away. We need to do something. And Martha, thank you so much. 9 months with subscribe to the Prime membership on Twitch. I appreciate that. Thank you so much. Thank you. Anyway, we were like, I made some peanut butter and jelly sandwiches. I grabbed some Pepsis and threw them in a grocery bag, a plastic bag. And we went to this local, it's like a campground. It's like a very big campground. But they have this huge lake on it, all right? And for an hour, you can rent a boat for $21 with this tiny little electric motor on it. So we got this boat for $21 and we went out on this boat for an hour. Just to get away, to breathe, okay? Well, unfortunately for Tiffany, it was her turn to drive the boat at the very end of the hour. So she was driving the boat at the end of the hour. Now, if you guys have never used one of these little electric motors on the back of a boat before, first off, when you're trying to turn a boat in water, it's not the easiest thing to do, to turn a boat. It's not like driving a car, where you can just pull in and pull out, turn the wheel. Water is different. It's very difficult to move and turn. You could usually do one or the other with ease, but not both. And by the time, you stop turning and start to move, you've overturned, or, it's just, if you think about a rowboat, when you're rowing, you row one paddle to try to turn, and by the time you're rowing both again, you're already turned way too far and you gotta row the other way anyway. It gets worse because the way the motor works is there's a stick on the front. Okay, alright? And if you want to turn left, you gotta turn this stick right. You gotta grab this stick and turn it to the right. Because that'll point the propeller, in the right direction to turn the nose to the left. Guitar Slinger, thank you so much for the alert. I love it. So if you want to turn to the right, you got to turn it the other way. Now, it's very difficult to get the hang of it first because the motor is not at all powerful. It's very, 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 very slow boat. It goes very, very slow. So you're already moving by the time you realizing you're going the entire wrong direction, and you overcompensate. And anyway, now at the end of the boat trip, to put the boat back, Tiffany had to back the boat in to the parking space. Now, okay. Now you would think that a police officer would want to come over real quick to find out why it was so crooked, right? Because this little girl really dislikes driving. It's not the best skill she had. Yo, my daughter took that boat in reverse and pulled it perfectly into that parking spot. And she didn't even slam into the dock. I am 100% sure, crookedly, I would have slammed into that dock. Right? But no, my daughter, she just reversed that boat right into that spot like she's been doing it for a million years. It was so cool. But that's how our boat trip ended today, so I'm happy. This court case reminded me of that. All right, back to the guy inferior to my daughter because he parks crookedly. Let's go back to him.
What did you speak with Mr. Voss about?
He had said that just seeing if it was his car that was parked crooked, which he said it was, and he'd mentioned that he had driven there to get help from his friend.
What did you notice about that car at that point?
With the car, he had said that he was in the process of getting new plates, but there was an expired temporary tag on the vehicle.
And you mentioned there were two vehicles, and one was crooked, is that correct?
Correct.
Which car was the crooked car?
Mr. Voss's.
And did you notice anything else about that vehicle?
Nothing that comes to mind.
And you mentioned Mr. Voss stated he hit a curb. Did you see anything about the vehicle that was consistent with that?
Yes, I did see damage around the vehicle.
And when you were speaking with Mr. Voss, what did you notice about him?
Initially, I noticed that his eyes appeared to be red, bloodshot, and watery. His speech was also slurred. And as we were talking, I could smell the odor of an unknown alcohol beverage coming from his person. Additionally, his balance appeared to be.
Hey, that's me after every single shift, especially the balance part. My feet hurt so bad I can't walk.
Unsteady as he was swaying while we were talking.
And did you ask Mr. Voss what he'd been doing that night?
Yes.
Was he able to provide you with a clear answer?
Not initially, no.
And did you ask him how he received the damage to his vehicle?
I did.
And how did he respond to that?
He didn't give me a clear answer about how he had gotten the vehicle or the flat tire, or the damage to his vehicle or the flat tire.
And seeing all that, did you offer Mr. Voss standardized field sobriety tests?
Yes.
And how did he respond?
He did not consent to them initially.
Okay. And after he refused those standardized field sobriety tests, what did you do?
I advised him that he was under arrest for driving under the influence.
Wait a second. Wait, she didn't see them park crookedly. She saw that they were parked crookedly. So how is that DUI?
And did he start saying anything at that point?
At that point, he was adamant that he did want to complete the standardized field sobriety test, stating multiple times he was willing to complete them.
Okay. And since he indicated then that he wanted to do the standardized field sobriety tests, what did you do?
I told him that if he would like to complete them, I would read his Miranda waiver. And at that point, he said that he would want to do them.
And when you said you would read him his Miranda waiver, did you read him his Miranda?
Hello?
Yes.
And was that off of your department issued card?
Correct.
And did Mr. Voss indicate if he understood the rights that you read to him?
Yes.
And how did he indicate if he wanted to speak with you at that time?
Yes.
And did he do standardized field sobriety tests at that point?
Yes.
Which test did you administer?
Oh, I did the horizontal gaze nystagmus test, the walk and turn, and the one leg stand.
And how did he perform on those tests?
He did not complete the test as compared to a sober person.
And about how many clues did you observe on the horizontal gaze nystagmus?
4 clues.
Unspoken hero is Adamant. He was great.
And after you administered well, I guess I want to back up for a moment. So prior to that Miranda advisal, did you ask Mr. Voss if he had been drinking?
I did.
How did he respond?
He denied that he had been drinking.
Did you ask him if he had smoked any marijuana?
He admitted to smoking marijuana, yes.
Okay. And then now going back to those standardized field sobriety tests, after you completed the roadside maneuvers, did Mr. Voss make any statements about drinking?
He then admitted that he'd been drinking and had a couple of beers prior in the evening.
And following his performance on the standardized field sobriety tests and his admission to drinking, did you advise him of express consent?
I did.
And did you do so off of your department issued card?
Yes.
Did you give him the option of a blood or a breath test?
Just a breath test because there was the thought of potential drug usage with the marijuana.
I think you said breath there. Did you mean just blood?
Blood. My apologies.
And did he agree to do a blood test at that
He
point?
did.
Okay. So I want to back up really briefly. You mentioned that Mr. Voss was unable to provide you with a clear explanation of what he was doing that night. Did he mention if he was at a bar?
He'd mentioned that he was briefly at a bar in Old Town, Arvada.
And was that prior to that Miranda advisal?
Correct.
Okay. Now, Officer Wilkerson, I want to talk about kind of your overall interactions with Mr. Voss. How many officers were on scene?
It was me and my sergeant on scene.
Yeah, we had Officer Wilkerson like a month and a half ago in a case. I can't remember which case, but I remember her because remember I said, that I used to work at a comedy club when I was 19, and one of the funniest comedians we had there was Ronnie Wilkerson. If you ever had a chance to see him, I don't know if you can. I don't know if he ever made it to the big time. He's hilarious. And she reminded me of him. We just saw this is the same girl.
And how would you describe your tone while speaking with Mr. Voss?
My tone was just conversational.
And when you were speaking with Mr. Voss, where were you located?
I was standing a little bit in front of my patrol vehicle, and we were standing in the parking lot as we were speaking.
Okay. And where was Mr. Voss in comparison to you?
He was ahead of me a few feet towards both the vehicles that I had previously mentioned.
And did you ever handcuff Mr. Voss during that initial conversation?
No,
Did you ever place any restraints on his movement?
no,
Did Mr. Voss ever indicate prior to refusing the standardized field sobriety test that he didn't want to speak with you?
no,
Did you ever threaten him?
no,
Did you ever make him any promises?
no,
To your knowledge, did any other officers at the scene ever threaten him?
no,
Did they ever make him any promises?
no.
And were you in uniform that day?
I was.
And does your uniform include a firearm?
Yes.
And did you ever draw that firearm?
No,
To your knowledge, did any other officer on scene ever draw that firearm?
no.
No further questions, Your Honor.
Cross-examination, Ms. Johnston.
Please. All right, good morning, officer. So first I want to talk to you about where you found Mr. Voss that night. You found him in the front passenger seat of a car, correct?
Correct.
Front passenger seat of the Jetta, because there are two cars there.
Yes.
Okay, so there's an Altima and there's a Jetta.
Yes.
And so you were poking around both cars. You eventually asked Mr. Voss to get out of the Jetta.
Can you define poking?
You got your flashlight, you're peeking into both cars, seeing what's in there.
Yes.
Okay. And so eventually you shine your flashlight at Mr. Voss and tell him to come out.
I asked him to step out. Yes.
Okay. And you asked for his driver's license at that point.
Correct.
Okay. So on the Altima, you saw that he had it, or that the Altima had a flat tire, correct?
Correct.
And that there are expired temporary tags.
Yes.
And you didn't actually see Mr. Voss driving that day.
I did not.
You didn't see like wheels turning driving, correct?
Correct.
You also didn't see him in the driver's seat of a car.
Correct.
And on direct examination, you testified that both cars were parked in that parking lot, correct?
Correct.
But only one was parked kind of cattywampus.
Yes, not a designated spot.
Okay, not in a designated spot. And would you recognize your body worn camera from that night?
I'm sorry, what was that?
Would you recognize a screenshot from your body worn camera that night?
If I saw it, yes.
Okay, approaching the witness, please.
Sure.
Does this appear to be a fair and accurate representation of your body worn camera that night?
Yes.
Okay, and so that is the Home Depot parking lot from that night?
Correct.
And you do believe that is your body worn camera?
Yes.
Okay, Judge, I'd like to admit and publish Defense Exhibit A.
Any objection?
No, Your Honor. The people will stipulate to the admission of the body-worn camera.
All right, you may publish.
Computer is frozen. I am fully frozen, Judge. 1 second. I think we're getting somewhere. All right, here we go. All right, and so Officer Wilkerson, this is a fair and accurate photo of what you saw that night?
Yes.
Okay, so we have the Altima a little bit crooked here, correct?
Correct.
And we see the Jetta is also crooked, is that correct?
Based on this, yes, that's correct.
Yeah, okay, so both of them are crooked. Okay. And Andrew Harris, that was Mr. Voss's friend that night, correct?
Correct.
Okay, Mr. Harris told you that Mr. Voss had just hit a curb and that's why he thought the tire was flat?
Yeah, he told me that Mr. Voss said he had hit a curb
Okay,
and then his tire was flat.
right. And later, Mr. Voss told you as much as well, that he thinks he hit a curb.
He didn't, from my recollection, provide a clear description of how the flat tire had occurred.
Okay, so he was just driving and then he said, at some point, I got a flat tire.
I don't recall the specifics.
Okay. And so let's talk about the indicia or the things you said you noticed about Mr. Voss. On direct, you mentioned he was unsteady on his feet and had slurred speech. Is that right?
Correct.
Okay. And so since the people have stipulated to admission of body worn camera for the purposes of this hearing, I would seek to admit and publish some body worn camera.
All right, you may publish, and that's Defense Exhibit A. Is that right?
I guess this would be B.
Okay, Defense B is admitted. Defense A is admitted if I didn't say that earlier.
Yeah. Do you have your license on you, sir? And you what?
I don't have like the actual plates of quiet.
Yeah.
Says got it.
Okay.
But yeah, my flat, my tire got messed up, so I've been handling him in ART.
Okay.
Say again?
Do you have your license though? Can you pull it?
But you were saying something.
So
Oh.
I usually my name up with Sean Ross.
Okay.
I have little ones for them.
Okay. No, I just like to know who I'm talking to. And are you guys like friends?
And so, officer, Mr. Voss wasn't swaying at all, was he?
Is there a question?
Was he wasn't swaying, was he?
It's hard to tell in this clip, but I did see him swaying as we were talking.
He was upright, he was talking to you, correct?
Correct.
And he was responsive to your questions.
Yes.
Okay. He's also wearing glasses that night.
I'd have to review it again. Sorry.
He was also wearing glasses that night.
Yes.
Okay. On direct examination, you testified that Mr. Voss had made a statement about smoking weed earlier that day,
Correct.
and he told you that he had smoked at 8 a.m. earlier that day.
I don't recall the exact time.
Okay. Okay. And it is 2 a.m. at this point, right?
Approximately.
Okay, so that'd be 18 hours since you last smoked.
Like I said, I don't recall the exact time that he had said he smoked, just that he had smoked marijuana earlier that evening, earlier that day.
Okay. Let's put a pin in that one. So for the video we just saw, we saw you shining a flashlight and gesturing for Mr. Voss to come out, correct?
Correct.
And your squad car was parked behind these two cars,
Correct.
and we can kind of see your headlights and your headlights shining into their cars.
It was just the position of my vehicle since it was a dark parking lot, so my headlights stay on when I
They said it was 2 a.m.
drive, which is why they're shining in this video.
Right. Okay. And you were armed in uniform that day.
Correct.
And Officer Kruppenbach, is that your sergeant?
No, that's another officer.
Another officer. Okay, so Officer Kruppenbach, he appeared around 2:10 a.m. Is that right?
I don't recall that.
Okay, and so you don't recall that he showed up?
No, from my recollection, it was my sergeant. I don't recall Officer Kruppenbach being there that night.
Okay. What's your sergeant's name?
Sergeant Mazzoni.
Mazzoni. All right. Was Sergeant Mazzoni the one who was talking to Mr. Voss with you?
I think at one point he had spoken with Mr. Voss.
Okay. When you were shining your light into the Altima, which you had identified as Mr. Voss's car, you didn't see.
Your mama is incorrect, although she's amazing and a superstar. She might be, on this one point, a little bit incorrect.
Any paraphernalia there?
Not that I recall, no.
You didn't see any open alcohol containers?
Not that I recall.
Okay. And you were asking Mr. Voss several questions, right? Like how he crashed his car.
I don't recall the specifics of the question, but I did ask how the damage had occurred.
Okay, so how he got a flat tire, right?
Correct.
Where he was coming from,
Correct.
where he was going,
Correct.
how much he had to drink,
Correct.
when he smoked weed last. And you also patted him down at 2:13, is that right?
I don't recall the specific time.
Okay. And that's because his hands were being in his pockets, right? Because it was super cold outside.
Yes.
So you're kind of, right, you know what, if you're going to keep putting your hands in your pockets, let's just give you a pat down. Is that right?
Yes, I did pat him down for potential.
Let's go to 2:13. Could find my cursor.
Yeah, can you just about with your vehicle, how did you crash it?
I didn't crash, I had a flat tire. So.
Which side?
So,
Okay, no, it's okay, just stay here. John's.
True, Sherry, you're right, Sherry. You're right.
I was driving pretty far.
Okay, where were you coming from?
Like Denver, Arvada, like.
Here, John, sorry to keep interrupting you. Can I just check you don't have weapons in your pockets? Okay.
Keep my coat on. I'm not.
No, you can keep your coat on. Let me just go like this. Interlock your fingers behind your head. Okay. I'm just gonna double check that you don't have any weapons. That way you can put your hands back in your pockets. Okay.
Okay, so you did a pat down of him at 2:13.
Yes,
And you had him interlock his hands over his head so that you could effectuate that pat down.
correct.
Okay. And then at 2:20 a.m., you and the other officer with you began to handcuff Mr. Voss, right?
Like I said, I don't know approximate times.
Okay. You and another officer at some time later tried or began handcuffing and arresting Mr. Voss, right?
Yes,
Okay. Prior to that, he had tried to end the questioning, right?
I don't recall.
Okay. And that's because the other officer had been asking him about his medication and confronting him with the supposed indicia that you all were seeing, right?
I don't know the conversation with the other officer.
PBT? My life's been, it's been really fucked up already.
Can I just look at your pupils with my flashlight?
You already showed it, like, I had epilepsy, seems like. He's on that.
You have epilepsy, what do you take for it?
I refuse, I did to, like,
Plead the fifth.
We just need to make sure, like, you don't have medical issues, right?
Do I gotta get you an ambulance? I gotta get you checked
no,
out?
he's wanting to drive me home, they're gonna tow my truck. Why would you do that?
Because right now you have behavior that's indicative of either intoxication or a medical episode.
Well, like I said, I have epilepsy and she just signed the med me, and I am fine, he's gonna drive me home.
So did you have an epileptic seizure while you were driving?
No, I'm done driving.
Okay. Well,
That's crazy, that's
the
not.
problem is I'm smelling alcohol and you're behaving as if you had alcohol
How?
and you wrecked your car. I can smell it. So that's a problem. You're slurring your words, you're kind of wobbly, your eyes are bloodshot and watery. And you wrecked your car and you don't remember how you wrecked
I
your car.
didn't wreck my car, as if you heard, I had a flat tire.
Your friend's telling us different stories, right?
Oh, he
So
doesn't hear me.
here's what we're gonna do. You can turn around, put your hands behind your back, you're under arrest. For DUI.
What? I don't understand. If I did the test though, I wouldn't do that?
Well, if you did the test, it would have,
Okay, I'll do this.
no, you can't do it that way now, man. But let me ask you this then, John.
What?
If you wanna do the test, we have to read you Miranda.
Yeah,
Do you know what Miranda is?
Yes.
Okay,
Okay.
Yeah.
Okay.
Talk to
I'm gonna
her.
read you your Miranda rights. Okay, sir, you have the right to remain silent. Anything you say can and will be used against you in a court of law.
Hi,
You have the right to
Casmic.
speak with an attorney and have him or her present during questioning. If you cannot afford an attorney, the court will appoint an attorney free of charge. Do you understand each of these rights I have explained to you?
Yes.
With these rights in mind, do you wish to speak with us now?
Maybe do it, right?
So it's just yes or no, you can stop this interview at any time, like I said. Are you willing to speak with us?
Yes.
Okay, so what we can ask, what my sergeant already asked, is if you'd be willing to blow in a preliminary breath test.
you have to, but that's at the end. Would you do voluntary roadside maneuvers? I mean, at this point, you're under Miranda.
Yes, yes.
Okay.
Okay.
I'm cold as fuck and that's somebody else's back.
Okay.
Okay. So just kind of break down that clip. Mr. Voss said that he had epilepsy, right?
Yes,
And then he was upset because you just shined a flashlight in his face.
yes,
Okay. And so your sergeant asked about the meds he was taking for that, right?
correct.
And Mr. Voss said, I plead the fifth.
Yes,
And then Sergeant Mazzone said, I plead the fifth. That's what we heard, correct?
correct.
Okay. And then I want to talk, and then Mr. Voss specifically said that he didn't want to talk to you all anymore, correct?
Sorry, when was that?
Over the course of this clip.
When he said he pled the fifth.
After he said he pled the fifth, he was done with questioning, correct? He said, I don't want to talk to you anymore.
I'm sorry, I don't recall what he said.
Okay, well, the clip's been admitted, so we'll just rest on that. But you all kept talking to him, right?
I think conversation did continue, yes.
Okay. And then when he tried to terminate this encounter, you and your sergeant went up and put hands on him to arrest him, correct?
Well, when the conversation continued, it was a non-custodial interview still at that point. We had not put cuffs on him yet.
Okay, and so he didn't want to do the voluntary roadsides at a certain point, right?
Right.
And that's the point when you handcuffed him,
Yes.
or began to handcuff, I should say.
Yes.
So you and your sergeant get on either side of him and start grabbing at his hands.
Correct.
Okay. And then you're mid-arrest, right? And he's like, wait a minute, I can't believe this is happening, right? And he asked you all, if I had consented, would things be different? Is that about what he said?
Yes.
Okay, not verbatim. And so your sergeant kind of takes over and he's like, well, if you want to do the SFSTs, then we'll reconsider the arrest. Is that basically what happened?
Not once did he say reconsider the arrest. He said if he'd be in the effect of willing to do the roadside maneuvers, we would have to read Miranda at that point.
Okay, and so you two stop handcuffing him, right?
Right.
Okay, and so because he says, all right, well, I'll listen to the Miranda, right? And I will potentially participate in the roadside.
Kristen, hello. I'm so glad you're here.
Yes.
Okay, and so you have begun handcuffing him and then you stop handcuffing him to read him Miranda
Correct.
in order to effectuate the SFSTs.
That he consented to.
Okay,
Yes.
and so after you read the Miranda advisement, he kind of hesitated, didn't he? When you said, do you, with all those rights in mind, do you wish to speak with us? And he kind of hesitated.
Well, it's, I guess it's not uncommon for people to need to read multiple times if they don't get an answer. So I needed a affirmative yes or no.
Right, because he said something like, I mean, I have to, right? That's what he said?
I don't recall the specifics.
Okay, and then you said, well, it's either a yes or a no. And then he said yes.
It is a yes or no if we were going to continue speaking, if he understood and wanted to continue speaking with Miranda.
Okay, and it was your sergeant's advisement to Mr. Voss that he had to waive Miranda in order to do SFSTs.
Based on what my sergeant said, yes,
Okay.
since he already refused to do them.
That's all for now. Thank you.
All right, Officer Wilkerson, thanks for your testimony here today. You may step down. Anything further from the people?
No further witnesses from the people, Your Honor.
We'll rest on the motion. Any evidence on behalf of the defense? Ms. Johnston.
Yes, Judge, the court does not wish for any additional argument.
Well, I asked if you had any evidence you wanted to present.
Oh, sorry.
That's okay. Okay, defense rests. All right, so argument, Ms. Johnston.
Thank you, Judge. I would rest on the motions and the case law they're cited therein. First, turning to reasonable articulable suspicion for a traffic stop. The test here is going to be Mr. Voss's reasonable belief as far as his freedom to leave and to disregard an officer's request for information and to terminate the encounter. That's under outlaw. Here we have a traffic stop. As soon as Officer Wilkerson flashed her flashlight into the Jetta, where Mr. Voss was seated in the front passenger seat and asked for his driver's license, that at that point, the investigatory traffic stop began. The facts of that
Cosmic, thank you so much. I appreciate it. Thank you.
Officer Wilkerson was aware of at that time was that the Altima had a flat tire. The Altima had expired temporary plates. She arrived at 2 a.m. thereabout.
I would have streamed it. Abso-freaking-lutely would have streamed it. I would have loved that.
And that's it. We have a parked car. We have two parked cars, parked kind of sideways, both of them. But we have no information about the timing of Mr. Voss's driving. We have no information about Mr. Voss's future plans to drive. In fact, it sounds like they're waiting on if I recall, they're waiting on a tow truck to tow his disabled car. There's no reasonable articulable suspicion of a crime having been committed, being committed, or about to be committed. Officer Wilkerson did not see any bad driving by Mr. Voss, didn't actually see him in actual physical control either. As far as probable cause for SFSTs and express consent, again, we have a parked car. We have Mr. Voss being found in the front passenger seat of another car. There's serious timing issues as far as express consent goes as well. It's unclear at what point that day, if it was the same day or the day before, since it was early in the morning, Mr. Voss was actually driving. The body-worn camera has been admitted. The court saw that Mr. Voss was actually standing upright, was not swaying, was not falling over. As far as other indicia, the officer testified to slurred speech and the smell of alcohol, as well as red and bloodshot eyes, though the officer did admit that Mr. Voss was wearing glasses that night.
Zach, thank you so much for the gifted memberships. I appreciate it. And you got Katy Perry. Nice. And thank you for being a member for 15 months. You're amazing. Thank you so much.
Then turning to the Miranda issue alongside the voluntariness issue. I would argue that Mr. Voss was in custody for the purposes of Miranda as soon as Officer Wilkerson shined her flashlight into the Jetta and gesturing for Mr. Voss to come out and asked him to identify himself. We have a squad car and then a second squad car parked behind their cars, two armed and uniformed officers, a second officer arriving at 2:10 a.m. I think in the final clip that defense admitted, the court can hear and see that the tone, I would not say, was particularly friendly, especially pertaining to Sergeant Mazzone and his confrontation of Mr. Voss. And Mr. Voss clearly did not take this to be a friendly encounter and actually asked to terminate questioning, said that he pled the fifth and said that he did not want to talk to the officers any longer. However, they persisted. Then a Miranda advisement was read at 2:20 a.m. after the officers began handcuffing him, and the officers said, well, okay, we can stop handcuffing you and we'll let you do SFSTs, but you have to waive Miranda. This court cannot find that any waiver of Miranda then would be voluntary. Under those circumstances, same with the SFSTs, after starting to arrest him and then saying, well, things might be different if you're willing to do these tests, there's no world in which that could be a voluntary choice by Mr. Voss. So I would move to suppress on that record. Thank you.
All right, thank you. People's response.
Your Honor, starting with at least the initial encounter here, the people would argue that this was a consensual encounter while Officer Wilkerson was acting in her caretaker capacity. She was on routine patrol at 2 a.m, observed two vehicles out front of in a parking lot in front of a closed Home Depot. She went there to kind of figure out what was going on, observed one of the vehicles had heavy damage, or not heavy damage, but damage and a flat tire, as well as expired tags. She at that point contacted Mr. Voss and to see kind of what was going on, what had happened, if they needed assistance. At that point, she did observe Mr. Voss had bloodshot watery eyes, an odor of alcohol coming from his person. He had slurred speech, as the court could hear in the body-worn camera, as well as appeared unsteady on his feet. At that point, Officer Wilkerson was trying to get an understanding of what he had been doing that evening, and he was unable to provide a consistent answer to her about what he had been doing and what had happened to his tire. He was able to state that he drove to the Home Depot, that at some point his tire was flat, and that at one point he had been at a bar. He also did admit to smoking earlier in the evening. at that point, given kind of that initial interaction being a consensual encounter, observing that indicia, she developed reasonable articulable suspicion, combined with those admissions, his statements, as well as the indicia. She did develop probable cause at that point that he'd been driving under the influence. When he did refuse standardized field sobriety tests, Officer Wilkerson and the sergeant began to place him in cuffs. At that point, Mr. Voss, on his own, said that he would do the test, that he wanted to do the test now. Officer or Sergeant Manzano then said, if you're going to do the test, we have to Mirandize you. He was Mirandized. He was let out of cuffs at that point, Mirandized. He asked, as Ms. Johnson pointed out, he kind of said, do I have to do this? And Officer Wilkerson, as the court saw on body-worn camera, said, no, you don't. You can end this conversation right now. At that point, Mr. Voss indicated that he did want to continue the conversation. He said yes. He then did standardized field sobriety tests, which he did not perform as a sober person would. So given that, Your Honor, the people would argue or ask that the court deny the defense motions. Here there was both reasonable suspicion and probable cause for the arrest as well as for express consent. It's clear from the testimony in the body-worn camera that he was not in custody prior to being cuffed, and then he was properly Mirandized, and Mr. Voss voluntarily and knowingly waived those rights.
All right, thank you. Well, what's the people's position on whether or not Officer Wilkerson told Mr. Voss that he had to waive Miranda if he wanted to do the standard field sobriety test? I think she said that she did say that to him. I understand.
My understanding of the statement was that she said, if we're going to do this, we have to Mirandize you.
I'm talking about the waiver of Miranda, about her testimony that, and maybe I'm misremembering the testimony, and I don't know, Ms. Johnston, if you remember it differently, but it sounded to me that the officer testified that she told Mr. Voss he had to waive Miranda in order to do the standard field sobriety test.
That was my last question, Judge.
And she said, yes, that's what I said. So what's the people's position on that?
Your Honor, I do believe, though, in the body-worn camera, he says, do I have to do this? And Ms. Wilkerson's response was that, no, you can end this interview at any time. I think that is sufficient to kind of overcome any issue of involuntariness.
So you're saying I should disregard the officer's response to the last question under oath?
I'm not saying you should disregard it, Your Honor, but take it in consideration with the totality of the other evidence presented, including when Mr. Voss specifically asks if he has to do this. Officer on the body-worn camera says, no, you can end this interview at any time.
Well, I don't know if the colloquy between Officer Wilkerson and Mr. Voss that she testified to was captured on the body camera. I'm going by her answer when she was asked that direct question, the last question that Ms. Johnston asked. Did you tell him he had to waive Miranda in order to do the standard field sobriety test? And her answer was, yes, I did. I don't know at what point that occurred. I don't know if that was captured on the body camera or not, but that was her testimony. I mean, Ms. Johnson, that's your recollection of the testimony?
That is. It was not verbatim from the body on camera, but I was trying to synthesize the interaction. And yes, that was my last question.
People agree that was the answer that was given by the witness?
Your Honor, I'm not disputing that that was the answer given by the witness. I would just point in Ms. Johnston's response as well. She said kind of that was a question synthesizing what was happening in the body-worn camera. And I think that was where Officer Wilkerson was coming from in the answer as well, that in order to do those standardized field sobriety tests, he had to be Mirandized at that point.
Had to be Mirandized or waive Miranda. That's the issue. That he had to be Mirandized. If they said, well, if you want to do the field sobriety test, then we have to Mirandize you. Okay, nothing wrong with that. But if you said, but if you want to do the standard field sobriety test, you have to waive Miranda, then that's a problem, I think, for the people. And that's the issue I'm honing in on, Mr. Harmon, is how can then the roadsides have been voluntary if he was told he had to waive Miranda to do them?
I understand the court's position, Your Honor. I do just think, while yet I'm not disputing Officer Wilkerson's testimony, I think the body-worn camera also provided a clear representation of what happened on that actual date that was presented, because that was the interaction that Ms. Johnston played for the court.
All right, well, the mayor's before the court on the defense motions to suppress for lack of reasonable suspicion, lack of probable cause, and to suppress statements and evidence as being involuntary. With regard to the initial contact, reasonable suspicion, this wasn't a typical sort of encounter between law enforcement and somebody who's driving because the vehicles were stopped in the parking lot and she didn't observe Mr. Voss driving. In fact, he was in the passenger seat when she came up on the vehicles. But it's not unreasonable for an officer at 2 a.m. in a parking lot when the business is closed, sees two cars sitting there parked kind of askew, to find out or try to find out what's going on. We would, in fact, I think, expect law enforcement to at least check into that situation, make sure everything was okay. So I don't find it was unreasonable for Officer Wilkerson to go up to the vehicles and to have her flashlight on. Again, it's 2 a.m. It's dark. Certainly for officer safety, that's not an unreasonable thing for her to do, to see who she's dealing with. So I don't find that to be a violation of Mr. Voss's rights, because at that point he had stopped voluntarily. It wasn't like the officer had stopped him or pulled him over. She was just coming up to find out what was going on and why they were in the parking lot at 2 a.m. So I don't find there's anything improper about the initial contact. In terms of having Mr. Voss get out of the vehicle, I don't find anything improper about that either, because again, for officer safety reasons, to find out who she's dealing with and what the circumstances are, that's a reasonable thing for an officer to ask. So Mr. Voss getting out of the vehicle and having an interaction, that was consensual. Mr. Voss talked to her and was answering, to some degree anyway, her questions about what was going on and what he was doing there. And just from a helping or assistance, perhaps a motorist assistance kind of a situation, that was sort of what it was seeming like initially, that he had a flat tire, that he hit something. He acknowledged that he was driving, although there was no time frame given on when he was driving, but he acknowledged at some point he was driving, hit a curb, had a flat tire. So the initial encounter was not improper. That was certainly something that law enforcement can do. As she was speaking with Mr. Voss, she began to notice signs of possible impairment, that his speech was slurred, and she testified his eyes were bloodshot, watery. I understand he was wearing glasses. That really goes more to weight, but that was her testimony, that that's what she saw. And that his balance appeared to be unsteady at times. That wasn't necessarily apparent from the body-worn camera clips that we saw, but she testified that she noticed that his balance was unsteady at times. And that she asked him what he was doing. Again, I don't find that to be any sort of a constitutional violation, because this wasn't a custodial situation at this point. A reasonable person in Mr. Voss's position would not have felt that they were under arrest. He wasn't being restrained. He wasn't being yelled at. He wasn't being coerced. She just asked, "What are you doing?" And she wasn't getting clear answers from him. That, again, could be an indicator of possible impairment. Then she asked him if he'd be willing to do voluntary roadside maneuvers. He declined. At that point, her sergeant was on the scene, and Sergeant and Officer Wilkerson went up and said, "You're under arrest for driving under the influence." Okay, well, certainly a reasonable person at that point is going to think that they're under arrest because he's being told he's under arrest. And then Mr. Voss says, wait a minute, can I do the roadsides? And he was told, well, now we're going to have to Mirandize you. Okay, well, there's nothing wrong because he'd been told he was under arrest. So I understand why the sergeant said that. So he said, we're going to Mirandize you. So a Miranda was given. But the problem is that Officer Wilkerson testified that he was also informed, Mr. Voss was, that if he wanted to do the voluntary roadside maneuvers, he would have to waive Miranda. He would have to waive his right to remain silent. So it was almost like there was some sort of quid pro quo going on here that, well, if you waive Miranda, then we'll let you take the roadside maneuvers. That can't be voluntary. If someone's being told you have to give up a right that you have, constitutional right that you have, in order to do something, that is not consent. So Mr. Voss at that point wasn't consenting to do voluntary roadside maneuvers. He indicated he wanted to do them, but when that statement was made that was testified to by Officer Wilkerson, you got to waive Miranda if you want to do the voluntary roadside maneuvers. At that point, those aren't voluntary. He's being essentially coerced into doing the roadside maneuvers by giving up a right that he has. So I can't find that the roadsides were then consensual at that point. And I'm going to suppress the roadside maneuvers, the results of the roadside maneuvers and the roadside maneuvers being given at that point, because I don't think it was voluntary. So the roadside maneuvers are suppressed. Obviously, that's in the people's case in chief. If for some reason the defense opens the door, then we might have another conversation about that. But at least as things stand now, in the people's case in chief, not going to be allowed to present evidence pertaining to the roadside maneuvers. With regard to probable cause, even though I'm suppressing the roadside maneuvers for purposes of trial, certainly I can factor in how Mr. Voss did on the roadside maneuvers in determining probable cause. And even though the jury's not going to hear about the roadside maneuvers, I have to view this in the totality of the circumstances when I'm making a probable cause determination. And under the totality of the circumstances, again, Mr. Voss acknowledging that he had driven, acknowledging that he had had at some point marijuana, acknowledging that he had had alcohol to drink, based on the officer's initial observations of signs of impairment, based upon all those totality of the circumstances and the roadside maneuvers, even though they're being suppressed for trial purposes, I do find that there was probable cause to invoke express consent and to place Mr. Voss under arrest sort of for a second time for suspicion of driving under the influence. As far as any statements that were made by Mr. Voss after the Miranda was given, I'm going to suppress those statements because I'm going to find it was, again, inherently coercive at that point that he had been told he had to waive Miranda in order to do the roadside maneuvers that he wanted to do. And so any statements that he was making at that point, from that point forward, I'm going to suppress those statements because I'm going to find that, again, it wasn't voluntary, that he was being told he had to waive his Miranda rights in order to do something. So any statements that he was making would then be, by definition, involuntary, not consensual. So I'm going to suppress any post-Miranda statements that Mr. Voss made. Pre-Miranda statements, I'm not going to suppress because at that point, again, a reasonable person would not have believed that they were under arrest. And so it was not a custodial interrogation situation. Miranda doesn't apply. So I'm going to allow those statements to be admitted in the people's case in chief. But any post-Miranda statements, frankly, everything that happened after that whole colloquy about Mr. Voss having to waive his Miranda rights in order to do something, that's something law enforcement shouldn't be doing. And I think that the suppression and exclusionary rule is appropriate to be applied under those circumstances. So the motions are denied in part and granted in part, I guess, is what we're finally doing at the end of the day. Ms. Johnston, any further record from the defense?
No, thank you.
Any further record from the people?
Your Honor, I would just ask clarification on the court's ruling if the suppression includes the blood results and express consent advisal.
Well, I'm finding probable cause, so there was probable cause to invoke express consent, so I'm not suppressing the blood test results. But I am suppressing the things that went on at the scene in terms of what Mr. Voss said and the roadside maneuvers. The jury's not going to hear about the roadside maneuvers. But I do find there was probable cause to invoke express consent, so I'm not suppressing the blood test results.
Thank you, Your Honor.
Okay, anything further?
Not from the defense.
Okay, thank you. We remain set for pretrial readiness on July the 21st at 11, and jury trial currently set August 3rd at 8. Good luck, Mr. Voss.
Okay, now you're the prosecutor. Do you go forward or do you dismiss this case? I mean, no one saw him drive that car. It was just his big mouth. But I think, I don't know. You got those dates.
Did we lose Ms. Johnston, do you think? Oh, sure, yeah.
Yeah, we're just,
Oh, no, there she is. Okay. Back up. This is 26M268, People of the State of Colorado versus Travis Oak.
Brady Harmon for the people.
Alika Johnston for Mr. Oak. He appears out of custody to my right.
Thank you. Good morning, Mr. Oak. Looks as though we have a disposition in this case. My understanding, Mr. Oak pleading guilty today to the charge violation of a civil protection order, Class 2 misdemeanor, non-domestic violence factual basis. Ms. Johnston, is that your understanding?
Yes.
Thank you. Mr. Oak, is this your understanding as well?
Yes, Your Honor.
All right. And Mr. Oak, did you go over this rights advisement along with Ms. Johnston?
I have.
You understand what your rights are?
Yes, Your Honor.
Do you have any questions about those rights?
No.
You understand, sir, pleading guilty means you're giving up your right to have a trial.
Yes.
And is that what you want to do?
Yes.
Have you had enough time to discuss the case with Ms. Johnston?
Yes.
And are you satisfied with her advice?
Yes.
All right, sir. Did anybody force you or threaten you or put any kind of pressure on you to get you to plead guilty?
No.
Were any promises made to get you to plead guilty?
No, Your Honor.
And today, are you under the influence of medication or anything else?
No, Your Honor.
So is your mind clear? Do you understand what you're doing?
Yes.
And is this a free and voluntary decision that you're making to plead guilty?
Yes.
All right, again, sir, the charge you're pleading guilty to, violation of a civil protection order, class 2 misdemeanor. Do you understand that charge?
Yes, Your Honor.
Do you wish to plead guilty to that charge?
Yes.
You understand the possible sentence that could be imposed on that charge?
Yes.
Counsel, anything further you would like me to advise your client?
No, thank you.
And you stipulate a waiver of factual basis. Thank you. All right, then, Mr. Oak, to the charge, violation of a civil protection order. How do you plead, guilty or not guilty?
Guilty.
As Mr. Oak has been advised of his rights, he's been represented by competent counsel, and that he is making a free, voluntary, knowing, and intelligent decision to plead guilty today. He's not been subjected to any undue influence, force, threats, coercion, or promises. He's not under the influence of medication or anything else. His mind's clear, and he understands what he's doing here today. Factual basis has been weighed. Court accepts the plea of guilty to the charge, finding it to be voluntary. People's position on sentencing.
Your Honor, the victim is present in court and I do believe would like to address the court.
Okay, thank you. If that person wants to come forward. Ma'am, good morning.
Good morning.
If you could just state your name for the record.
My name is Bambina Simard, last name spelled Simard.
All right, thank you. And what would you like to say, Ms. Mark?
I would just like for the courts to be aware of the fact that he did this within 24 hours of being delivered the paperwork for the order. And the position that I'm in with the lack of evidence for any kind of domestic violence is understandable because of how everything happened. But I just would like for the courts to be aware of why the protection order was in place, and that after the hearing for the actual order that it was put in place permanently, and have that be known.
Okay, ma'am, I understand what you're saying. I appreciate you being here today. Thank you. And you can go ahead and resume your seat, Ms. Mark.
Thank you very much.
Thank you. Okay, Ms. Johnson, if you and your client want to return to the microphone, thank you. Mr. Harmon.
Your Honor, the people are asking for a period of probation in this case as a sentence. We have no objection to that being concurrent to his probation in 25 CR 2482. In the present case, Your Honor, as the victim stated, here Mr. Oak, the day after being served with a temporary protection order, went within 100 feet of the residence. He dropped off a bunch of items in the driveway. He appeared like he may have been going to the residence, but was seen by the victim's father and then left. Your Honor, I do feel that some ongoing monitoring is appropriate here, given that he was aware of the protection order. When he went to the home, it was, like I mentioned, immediately after being served with that protection order. Aside from the present offense, Your Honor, he has this is I believe a first or it's non-DV, but he doesn't have any prior DV offenses. He does have what I mentioned, which is 25 CR 2482.
Hi, Nancy.
That is with a separate victim.
Thank you, Ms. Johnston.
Thank you, Judge. I'd be asking this court to close this case with the 3 days of pre-sentence confinement credit that Mr. Oak has. First, talking about the other case that Mr. Oak is supervised out of, that is a case that never contemplated domestic violence charges. So I just want that to be very clear for the court. That was not pertaining to any intimate partner or person with shared children. Mr. Oak has really been put through the ringer with this case and the companion civil protection order. I think unlike in situations where someone is advised under 18-1-1001 in court and an attorney's there to advise them as to what is going on with the protection order, here a process server who is the friend of the named victim's father served Mr. Oak with a piece of paper. That to me, that process is really, really different. And then yes, legally we do impute knowledge, but I think this court might understand that the actual depth of understanding, of comprehension of what is in the protection order may be different. Mr. Oak and the named victim here have two shared children. It has been tremendously painful for Mr. Oak to no longer be able to see his two young children. And to him, from his perspective, this was a whirlwind 24 hours where he is no longer able to see his kids. He's been served with this scary looking piece of paper by her dad's friend, and he still has some of her stuff. So he went over, dropped off the baby stuff and Miss Simard's stuff, like her mail, on a table, and that's it. He acknowledges with his plea today that he did violate the terms of the civil protection order that he should have been aware of. But Judge, this plainly was not an act of domestic violence. This is a here's your stuff. Sorry it had to be like this kind of situation. I'm happy to say that Mr. Oak is doing better. He lost his job as a result of this case, but things have been turning up. He is an electrician apprentice. His company is really investing in him, willing to put him through trade school. So things are looking up. Previously, he was an HVAC. And sorry,
It was fire alarm. But
fire alarm.
it was another trade.
A different trade, but he's things are going better. He has a new relationship where he's things are feeling supportive. So Judge, understanding that this was just plainly not an act of domestic violence, but it was ill-advised, I'm asking to close this case with those 3 days of pre-sentence confinement credit, understanding that Mr. Oak remains supervised in that other case.
Ill-advised. I think that's the wrong ill word. What was it? Ill. What's another way we could describe him going to that house after he got that protection order? Oh, I know. Illegal.
Case, but if not, I am asking this court to run any probationary sentence concurrent to that other case.
All right, thank you, Mr. Oak. Was there anything you wanted to add or anything you think I should know?
Just that this wasn't meant to be an act of intimidation or to threaten anyone. If there was any ulterior motive for my actions, it was that I would hopefully get to see my kids for one day before all of this happened.
All right,
I didn't.
Oh, go ahead, Mr. Oak.
I didn't get to see them. Nothing. It wasn't worth it. None of it was.
All right, thank you, Mr. Oak. Mr. Oaks pled guilty to the violation of a civil protection order, Class 2 misdemeanor. Conviction enters on that charge. That is significant in and of itself because now he does have a conviction. And it sounds like he is on probation out of that district court case, 25 CR 2482. In terms of the facts of this case, obviously a bad decision, Mr. Oak. I'm guessing you would agree with that. And I can understand why Ms. Simard feels the way she does in terms of she had that protection order and then there you were, and all of a sudden it's like, well, what's he going to do next? I get that. Looks like you get that as well. But I don't think your intent here was to send a threatening message or I'm going to, retaliate against you for getting this protection order. I don't think that was anything that was going on at all. I think it was just a really bad decision to go over and leave stuff, and you didn't even have direct contact with Ms. Simard. Now, it's a protection order, and that's an order of the court, Mr. Oak, and that's significant because, when courts issue orders, people are to follow them. If they don't, there's going to be consequences. But this is a consequence right now. The fact that you've pled guilty, you've taken responsibility for the bad decision that you made. And in terms of probation supervision, the facts of this case really don't give rise to any sort of issues that I think Mr. Oak needs to be monitored on. He's being, obviously, on that felony case, he's being supervised. And if he doesn't comply with probation in that case, there's going to be significant consequences probably. But that was not a domestic violence case. If it was, my radar would be a little more sensitive right now. And you don't have any prior domestic violence contacts with the police or arrests or anything that I'm seeing on your history, Mr. Oak. So again, I don't think that you are a domestic violence offender. I think you're a guy who made a really bad decision, but I understand the surrounding circumstances. And you spent 3 days in jail on this thing, and it sounds like that had some consequences for you in terms of your job and that sort of thing. Is that right, Mr. Oak?
Yes, Your Honor.
Okay, so
I don't know if we're going to hear that. Is it Chucky's interpreter? I do know that we have another hour to go, but I have no idea what happens during that hour. We're all going to find out together.
That's enough, frankly. So I'm going to assess the fees and costs I have to assess for a Class 2 misdemeanor. Sentence Mr. Oak to 3 days in the county jail, giving credit for the 3 days that he served. No protection order ever entered in this case, so we don't have a protection order in place here. Sounds like there's still that permanent civil protection order. Obviously comply with that, Mr. Oak. And I'm guessing you have, because as far as I'm aware, you haven't picked up any subsequent violations of the protection order, so you got to comply with that protection order, as well as any other orders that are in effect, particularly in your probationary case. But in terms of this case, I just don't see any issues that would be served by putting Mr. Oak on probation supervision and probably starting to duplicate services. So the case is closed. Good luck, Mr. Oak.
Thank you.
Go ahead. There's a Arapaho and he'll leave if. There it is.
All right. Thank you. This is 25M 5795, People of the State of Colorado versus Manuel Ortiz.
Call up order for the people.
Robbie Nikon on behalf of Mr. Ortiz. Mr. Ortiz is in custody at the Arapahoe County Jail. I'm not seeing him on screen at the present.
Okay, thank you. We're set for pretrial readiness in this case. Currently, we're set for jury trial on July 20th. Are the people calling ready and proceeding to trial?
Your Honor, we would just ask for a status at this point. We did reconvey a new offer to Mr. Nikon, but other than that, we are checking on a couple subpoenas.
Mr. Nikon?
I did receive.
Calling ready?
I would also be asking for a new status conference, maybe before next Tuesday's meeting. The offer that I received it yesterday afternoon, and I appreciate Mr. Porter relaying it. I just haven't even been able to advise my client of it. I think that it will probably resolve, but I just ask for the status between now and the 20th.
All right, well, it sounds like at least there's a reasonable possibility of a disposition in the case, so we'll set it for a continued pretrial readiness / status before July 20th.
Yes. Well, how many times do you want to just do?
Yes. Well, and sorry, waiving his appearance today, yes, but we could do a plea at the upcoming status. We could also do the plea the morning of trial, but I know that is probably not what the court would prefer, I would imagine.
I would prefer not to do that.
That is an interesting question, Hanky Panky Mom. That is. I wonder. I don't know.
Okay. Yeah.
Strongly prefer not to do that. So we'll.
17th at 8 a.m.
All right, July 17th at 8 a.m. for status / disposition. DA to video writ, Mr. Nikon.
That works for us.
Video writ from Arapahoe.
Thank you.
Okay, thank you.
She's adding.
This is case 25M25247, People of the State of Colorado versus Michael Seliketic.
Call up order for the people.
Robbie Nikon on behalf of Mr. Seliketic. Mr. Seliketic is out of custody. He joins me at the podium, standing to my right.
Thank you. Good morning, Mr. Seliketic.
Good morning, sir.
Case set for pretrial readiness today, although it's as though the people are moving to dismiss. Is that right, Mr. Porter?
That's correct, Your Honor. We haven't been able to contact the victim in this case throughout the case. With that being said, moving to dismiss because we don't think we can prove this beyond a reasonable doubt at trial.
All right, thank you, Mr. Nikon. I'm guessing you're all right with that.
Just fine with us.
I'm sure that's okay with you, Mr. Seliketic. All right, then, on the motion of the district attorney, the case is dismissed and closed, ordered sealed, and the jury trial that we had set for July 13th is vacated. Any protection order that issued in this case is also vacated. Anything further, Mr. Nikon?
If we could just get a copy of the dismissal and sealing for my client, I'd appreciate it.
Boss?
All right.
Okay, good luck, Mr. Silicato.
Yes, so please. Bravo.
This is an interpreter.
No, Chucky's, yep, they're online. I don't know if yours.
This is 25M4226, People of the State of Colorado versus Johnny Thomas.
Freddie Harmon for the people.
Robbie Nikon on behalf of Johnny Thomas. Mr. Thomas is out of custody. He joins me at the podium standing to my right.
Thank you. We have an interpreter.
Good morning, Your Honor.
Good morning. If you just want to add your appearance, please.
Yes, my name is Jill Short, Chuki's interpreter.
All right, thank you. And good morning, Mr. Thomas.
Nisaran Nimngoruk, Mr. Thomas.
Matter set for pretrial readiness today, currently set for trial. Sorry, forgot. Go ahead.
My apologies, Your Honor. Please continue the full.
Okay, we're currently set for trial on July 22nd. And now I'm done for the moment.
Ewer kiriso tapu raura punikere si preferio muy temporaus. Aura pun omna trial. Often scheduled and epophisitiu 1 July Romeru.
Are the people calling ready and proceeding to trial?
I see the attorney. Ike irmi mocenat si pure nongeri ana trial. Ike irmi moratangeri kamed.
Your Honor, the people are calling ready and are prepared to proceed to trial.
Aura meipu si pure tak nongeri awa trial.
Is the defense calling ready and proceeding to trial, Mr. Nikon?
Apuan kapases ngiri Mr. Nikon ika iya apuan moratangeri awa trial.
Yes.
Ewer.
All right, both sides call ready for trial.
Rapun eka ruevan irmi tsukpan ready ka moratangeri.
We have any issues other than that to address on the record today?
Pare sirir ika mioraro sukosuki ka metsi pure poraus warreni kere.
Not from the people, Your Honor.
Rap eseor senio estate.
In speaking with Mr. Porter, it sounds like the people now only intend to call Officer Guerra.
Oh, I repun aporaus ngiri awa evan attorney. I repun reporeta kakuri evan. Champorata, Officer Guerra.
So I think that the good faith witness list is a little outdated, but I just want to confirm that I'm preparing for the right officer and that it's only Guerra.
Oh, eura repunera list. Ikata terin. Ekana champorata, raffenatura. Ese chiwenpung. Irapota. Awasora. Atsek repuna, atsek morata ngiri ewe evan champorata.
Is that the people's understanding?
Apan metewe state apan tepe ngiri.
Yes, Your Honor, the people only intend to call Agent Guerra at this time.
Meipung, sokopung. Sibure tsukakuri ewe evan police officer Guerra.
All right, with that, Mr. Nikon, anything further?
No, Your
Mr.
Honor.
Nikon meor parakots poraus poraus warreni kere.
Nothing further from the defense, no.
Ap esipani orkriso.
All right, we did have a pretrial services report, but it looks like that's from May.
I repura parkatonera pretrial services report sinime.
Just remind Mr. Thomas that he does remain on pretrial supervision.
Ewer aura pun Mr. Thomas ko putuk fakun chichimeri pun ekana annuk.
Okay, that right there sounded like she swore at him.
Tiwen paturungoruk. Ko puretuk pantaparoma anesotisi ekana annuk.
And I don't know where this case is going to wind up in terms of priority on July 22nd.
Oh, repun esesideika epore fis krokvite. One, did you say July or August? I'm sorry, Your Honor.
July.
Or 1 July rumeru eseside krokvite epore popite.
She starts every sentence with "oh." That's how I start every action. Oh.
But as things stand today, the case will proceed to trial on that date at 8 a.m.
Ngayon, si Puretzak Puan. Nuwan sa Ferito, Zulay Romaru, Kalakwaru, Sipwe, Apoputariara trial.
Good luck, Mr. Thomas. My thanks to the interpreter.
And what Kiriso, good luck, Moruk, Mr. Thomas. Upon Kiriso, Ngiringanga, what's on Tiaku. Kiriso Pontiro.
Thank you.
Thank you, Your Honor. I don't believe I have any other Chukis cases at this time.
I think that was probably it.
Okay, thank you.
I don't know. Wait, you should double check. I've never even heard of that language before, and she did a fantastic job.
This is 22M 1676, People's State of Colorado versus Joshua Lloyd Fluitt.
Brady Harmon for the people.
Simon Hacker on behalf of Mr. Lloyd Fluitt, who appears out of custody to my right.
All right, thank you. Good morning, Mr. Lloyd Fluitt. You're in a pending probation revocation complaint and addendums to the complaint. Are the people still pursuing the complaint and the addendums?
Yes, Your Honor.
Wait for any further advisement, Mr. Nikon.
No, Your
Or,
Honor.
I'm sorry, Mr. Hacker.
That's all right. I knew what you meant.
I'm still in the Nikon mode. Let me get out of that. Okay. Mr. Hacker, do you waive that?
Yes.
Thank you. How would you like to proceed?
At this point, Your Honor, Mr. Lloyd Fluitt is going to admit to the technical allegations in the complaint.
All right, thank you. So, Mr. Lloyd Fluitt, my understanding, sir, is you want to admit that the allegations in the complaint and the addendums are true. Is that what you want to do today?
Yes, Your Honor.
You understand by doing that, you're giving up your right to have a hearing. Do you want to give up your right to a hearing? Have you had enough time to discuss this with Mr. Hacker?
I have, sir.
Not Mr. Nikon, but Mr. Hacker. All right, are you satisfied with his advice?
I am.
All right, sir, did anybody force you or threaten you or put any pressure on you to get you to do this today?
No, sir.
Anyone make any promises to get you to do this?
No, sir.
And today, are you under the influence of medication? Anything else? So is your mind clear? You understand what you're doing? And this is a free and voluntary decision that you're making to admit to the allegation.
Oh, absolutely. She could charge anything she wants. Because what are they going to do? I don't know why, but this judge is growing on me. I would love to see him be challenged. I would love to see how he handles it.
It is.
All right.
He just seems like he would fight back with, he would make them feel stupid by just laying out facts and facts and facts.
Sir, the allegations are that you did violate probation, specifically that you had a UA test on January 31st of 2023. That was positive for THC and alcohol, and that you had 5 UAs that were positive for alcohol on October 13th, November 7th, November 15th, November 17th, and November 22nd of 2023. Do you admit that that allegation is true? Next up, between December 8th of 2022 and January 10th of 2024, that you failed to submit to 21 out of 56 UA tests. And as of the filing of the complaint, you most recently missed UA tests on December 28th of 2020.
How? Come on. We are almost done with this year. And he started missing tests last year. How do you miss that many tests? How do you blow dirty that many tests? How? How do they just say, okay, we'll try again next week. This is your 15th time. You better not do it again. How?
23, January 5th, and January 9th of 2024. Do you admit that that allegation is true? Next, that as of the filing of the original complaint, that you had failed to attend IOP treatment since February 7th of 2023, that as of the filing of the complaint, you had failed to contact any agencies to continue with treatment, that on November 29th of 2023, you referred to Hazelbrook Sober Living, and that you did not pursue treatment at that location. And on December 19th, you referred to the VA to enroll in substance abuse treatment, and as of the filing of the complaint, you had failed to enroll into treatment. Do you admit that those allegations are true?
Yes, sir.
Next, that you failed to appear for 2 scheduled probation appointments on February 10th and December 8th of 2023. Do you admit that those allegations are true?
Yes, sir.
And in the first addendum, It is alleged that you violated probation by failing to submit the 2 UAs on January 25th and January 29th of 2024. Do you admit that that allegation is true?
Yes, sir.
That on January 23rd of 2024, you referred to VA to enroll in substance abuse treatment. As of the filing of the addendum, you had failed to enroll in treatment as directed. Do you admit that allegation is true? And in the next addendum, it's alleged that you violated probation, specifically that on March 19th of 2024, you reported to probation. Probation suspected you to be under the influence due to smelling the odor of alcoholic beverage coming from your breath, that a portable breathalyzer test was administered and you blew a .233. Do you admit to that allegation?
Yes, sir.
Next, that you failed to submit to 4 UA tests on February 9th, 13th, March 6th, and March 13th of 2024. Do you admit that that allegation is true?
Yes, sir.
Next, that as of on February 28th of 2024, you were given contact information for VA again to enroll into treatment. As of the filing of the addendum, you are not engaged with treatment. Do you admit to that allegation?
Yes, sir.
And finally, that you failed to report for a scheduled probation appointment on February 14th of 2024. Do you admit that that allegation is true?
Sure.
Court finds that Mr. Lloyd Fluid has been advised of his rights. He's been represented by competent counsel, and that he is making a free, voluntary, knowing, and intelligent decision to admit to the complaint and the addendums. He's not been subjected to any undue influence, force, threats, coercion, or promises. He is not under the influence of medication or anything else. His mind's clear. He understands what he's doing here today. Court accepts the admissions, finding them to be voluntary. You find a violation of probation in this case. Regard to resentencing, any position for the people or input from probation?
Probation was going to be here, but we have their recommendation. Essentially, they just wanted to terminate this unsuccessfully, leaving a sanction up to the court. Probation noted that he was doing fine recently, although looks like his scram device hadn't been charged for a bit and wasn't necessarily responding to contact him regarding the issue of charging his scram device. Your Honor, I think based on the age of the case, understanding that there are a lot of allegations that have been admitted to today, but noting that this is a drunk with gun case, it's from 2022. There really hasn't been any new law violations, at least that I can see, since then, other than just this non-compliance. I just think closing the case unsuccessfully is appropriate at this time. As it pertains to a potential sanction, again, noting that although the quantity of non-compliance seems to be relatively large, the aggravated nature, or I guess the non-aggravated nature of those violations, I think would lead us to just recommending to close the case and getting Mr. Lloyd Fluid out of here.
Is that going to be your request, Mr. Hacker?
Very similar. I was intending to ask first to close successfully and then to close unsuccessfully with no further sanction. I have a pretty lengthy contextual argument for the court if the court's inclined to hear it.
Noting the time, Mr. Hacker, and noting the number.
Abso-freaking-lutely not. No. Absolutely not. This guy did absolutely nothing. Probation is in lieu of jail. He did not go to jail. Therefore, he has to do probation. He did not do probation. Close it successfully and then close it unsuccessfully? Absolutely not.
Number of cases I have up here, my intent would be to terminate probation unsuccessfully, refer any outstanding fees or costs to civil collections, and close the case.
That's fine with defense, Your Honor. Thank you.
All right, Mr. Lloyd Fluid, was there anything you wanted to add or anything else you think I should know, sir? All right, well, this is a case where Mr. Lloyd Fluid pled guilty to prohibited use of weapons, drunk with gun, and he was placed on probation originally for a period of 1 year back in, looks like November of 2022. In terms of the probation complaint, it's there's a lot of allegations that Mr. Lloyd Fluid has admitted to today, but there are no new law violations. And it sounds like it's just been kind of a rocky road on probation, Mr. Lloyd Fluid. And in terms of any sort of community safety risk, well, the charge is concerning since you haven't picked up any new law violations, and it's been mostly just essentially noncompliance with treatment and monitored sobriety testing. I don't think there's any point in continuing that right now. There doesn't seem to be any reasonable likelihood of success on probation. Not to say Mr. Lloyd Fluid's a bad guy or anything like that, but it just doesn't seem to be working. So I think it's time we just ended this thing. So again, probation is revoked and terminated unsuccessfully. Any outstanding fees or costs are referred to civil collections. And the case is closed.
I mean, there is one bad thing that will become of this. So it's closed unsuccessfully. So that means if he breaks the law again and he tries to get probation, they're going to see that he doesn't do well in probation. So he could, if he breaks the law again, it definitely lowers his chance of getting probation, although it sounds like he probably will get probation again. I don't know. He hasn't broken the law again.
Good luck, Mr. Lloyd Fluid.
Thank you, sir.
Jackie, do you have any paperwork for Mr. Lloyd Fluid? Any paperwork for Mr. Lloyd Fluid?
You're done. You're good to go.
These are cases 25M5215, 26M26120, People's State of Colorado versus Jamie Hicks.
Colin Porter for the people.
Simon Hacker on behalf of Ms. Hicks, who appears in person to my right.
All right, thank you. Good morning still, Ms. Hicks. Looks as though we have a disposition in the two cases. My understanding is that in 25M5215, Ms. Hicks pleading guilty to an added count 2, attempted harassment, strike show of care, class 2 misdemeanor, factual basis of domestic violence. And the other case, 26M26120, would be dismissed in its entirety. And Ms. Hicks would then be placed on a deferred judgment and sentence as to the attempted harassment charge for a period of 18 months, supervised by probation. Mr. Hacker, is that your understanding?
Yes, Your Honor.
Thank you. Ms. Hicks, is this your understanding? All right, and Ms. Hicks, did you go over this rights advisement along with Mr. Hacker? Do you understand your rights?
Yes.
Any questions about your rights?
No.
You understand, ma'am, that pleading guilty means you're giving up your right to have a trial? And is that what you want to do?
Yes.
Have you had enough time to discuss the cases with Mr. Hacker? And are you satisfied with his advice? All right, ma'am, did anybody force you, threaten you, or put pressure on you to get you to plead guilty? Anyone make any promises we haven't talked about to get you to plead guilty?
No, sir.
And today, are you under the influence of medication? Anything else?
No.
So is your mind clear? Do you understand what you're doing?
Yes.
Is this a free and voluntary decision that you're making to plead guilty?
Yes, sir.
All right, again, ma'am, the charge you're pleading guilty to, attempted harassment, class 2 misdemeanor, factual basis of domestic violence. Do you understand that charge?
Yes, sir.
Do you wish to plead guilty to that charge?
Yes, sir.
Do you understand the possible sentence that could ultimately be imposed?
Yes, sir.
And you understand that by agreeing to a factual basis of domestic violence, that at least during the period of time of your deferred judgment, your ability to purchase, own, or control firearms, ammunition would be prohibited. If a conviction ever ultimately entered in the case, that would become a permanent prohibition. You understand that?
Yes, sir.
And the way the deferred judgment works, Ms. Hicks, is that if you do comply with the terms and conditions, then at the end of 18 months, your plea of guilty to the charge would be withdrawn, the charge would be dismissed, the case would be closed, and no conviction would enter on your record. On the other hand, if you don't comply with the terms and conditions, then a motion could be filed to revoke the deferred judgment. If that happened, hopefully it doesn't, but if it did, you would be entitled to have a hearing as to whether or not you'd violated the deferred judgment. However, you would not get a trial on the charge because you're giving that up by pleading guilty here today. You understand that? And if things ever did come to the point, again, hopefully it never will, but if it did where the deferred judgment was revoked, then the conviction would enter and then you'd be subject to sentencing on this charge. You understand that?
Yes, sir.
Understanding all of these things, do you still wish to plead guilty?
Yes, sir.
Counsel, anything further you'd like me to advise your client?
No, thank you, Your Honor.
And do you stipulate to a factual basis and a factual basis of domestic violence?
Yes, Your Honor.
Thank you. Any victims' rights record from the people?
Yes, sir. I did have the chance to speak to Mr. Paul Martinez. He is in the courtroom today.
All right, thank you. Find compliance with victims' rights. All right, then Ms. Hickson, 25M5215 to the added count 2, attempted harassment, factual basis of domestic violence. How do you plead, guilty or not guilty?
Guilty.
Court finds that Ms. Hicks has been advised of her rights. She's been represented by competent counsel and that she is making a free, voluntary, knowing, and intelligent decision to plead guilty today.
My high school best friend married a Paul Martinez, but I doubt it's the same person because that's a very common name.
She's not been subjected to any undue influence, force, threats, coercion, or promises, is not under the influence of medication or anything else. Her mind is clear and she understands what she's doing here today. Factual basis has been stipulated, including a factual basis of domestic violence. Court accepts the plea of guilty to the added count 2, finding it to be voluntary. Count 1 is dismissed. 26M26120 is dismissed in its entirety. I do make findings of domestic violence pursuant to 186800.3. And in accordance with the agreement that's been reached, I will place Ms. Hicks on a deferred judgment and sentence for a period of 18 months to be supervised by probation with a return date of January 7th, 2028. And ma'am, you don't have to appear in court on that date unless you've been notified if everything's gone the way it's supposed to go and you've complied with everything. Then a motion gets filed with the court. Please withdraw. Case is closed. That's the end of the matter. However, if a motion does get filed at some point over the next 18 months to revoke or to modify the deferred judgment, you would likely have to make a court appearance on that. I'll assess fees and costs I'm required to assess for a Class 2 misdemeanor. Anything further from the people?
No, Your Honor.
Mr. Hacker.
No, Your Honor.
Ms. Hicks, any questions about this, ma'am?
No, thank you.
Good luck. We're going to get you some paperwork. You'll check in with probation, make sure they have good contact information for you, and just let them know what's going on, Ms. Hicks. Communicate effectively. That's the best way to get through this. Just make sure they know what's happening with you and be proactive in addressing any issues. And hopefully when the time comes, we can close it out successfully. Take care, ma'am.
Guys, if any other ROAs are floating around, they need to be up here.
This is 26M1322.
Yeah, wait, whoa. It sounds like she should be the judge. Put her on the bench, sir.
State Colorado versus Evan Snyder.
Brady Harmon for the people.
Ryan Cornegie, Mr. Snyder, in person.
Thank you. Good morning, Mr. Snyder.
Good morning, Your Honor.
Looks like we have a disposition today in this case. My understanding, Mr. Snyder pleading guilty to an added count 2 of harassment, strike, shove, kick, factual basis of domestic violence. Count 1 would then be dismissed. And Mr. Snyder would be placed on a deferred judgment and sentence for a period of 18 months as to the harassment charge. Counsel, is that your understanding?
It is, Your Honor.
Thank you. And Mr. Snyder, is this your understanding as well?
It is, Your Honor.
Mr. Snyder, did you go over this rights advisement along with your attorney?
I did, yes.
You understand your rights?
I do.
Any questions about your rights?
No, Your Honor.
And you understand, sir, pleading guilty means you're giving up your right to have a trial?
I do.
And is that what you want to do?
Yes, it is.
Have you had enough time to speak to your attorney about the case?
Yes, I have, Your Honor.
And are you satisfied with the advice that you've received?
I am.
All right, sir. Did anybody force you or threaten you or put any pressure on you to get you to plead guilty today?
No, Your Honor.
Anyone make any promises that we haven't talked about to get you to plead guilty?
No,
Today, are you under the influence of medication or anything else?
I am not.
So is your mind clear? Do you understand what you're doing?
It is, Your Honor.
And is this a free and voluntary decision that you're making to plead guilty?
Yes, it is.
All right, again, sir, the charge you're pleading guilty to is harassment, Class 1 misdemeanor, factual basis of domestic violence. Do you understand that charge?
I do, Your Honor.
Do you wish to plead guilty to that charge?
I do.
You understand the possible sentence that could ultimately be imposed?
I do, Your Honor.
And you understand, sir, that by agreeing to a factual basis of domestic violence in the case, that at least during the period of time of your deferred judgment, your ability to purchase, own, or control firearms or ammunition would be prohibited.
Zach, are you still here? I need to know.
If a conviction ever entered in the case, that would become a permanent prohibition. You understand that?
I understand, Your Honor.
And the way the deferred judgment works is that if you comply with the terms and conditions, then at the end of 18 months, your plea of guilty to the charge would be withdrawn, the charge would be dismissed, the case would be closed, and no conviction would enter on your record. On the other hand, if you don't comply with the terms and conditions, a motion could be filed to revoke the deferred judgment. If that happened, hopefully it doesn't, but if it did, you would be entitled to have a hearing as to whether or not you'd violated the deferred judgment. However, you would not get a trial on the charge because you're giving that up by pleading guilty here today. You understand that?
I do, Your Honor.
And if things ever did come to the point, again, hopefully it never will, but if it did where the deferred judgment was revoked, then the conviction would enter and then you'd be subject to sentencing on this charge. You understand that?
I understand, Your Honor.
Understanding all these things, do you still wish to plead guilty?
Do. Yes.
Counsel, anything further you'd like me to advise your client?
No, Your Honor.
And you stipulate to a factual basis and a factual basis of domestic violence?
Yes.
Thank you. Any victim's rights record from the people?
Your Honor, the people are VRA compliant. The victim does appear in court today.
All right, thank you. Find compliance with victims' rights. All right, then, Mr. Snyder, to the added count 2 of harassment, factual basis of domestic violence, how do you plead, guilty or not guilty?
Guilty, Your Honor.
Court finds that Mr. Snyder has been advised of his rights, he's been represented by competent counsel, and that he is making a free, voluntary, knowing, and intelligent decision to plead guilty today. He's not been subjected to any undue influence, force, threats, coercion, or promises. He's not under the influence of medication or anything else. His mind's clear. He understands what he's doing here today. Factual basis has been stipulated, including a factual basis of domestic violence. Court accepts the plea of guilty to the added count 2, finding it to be voluntary. Count 1 is dismissed. I do make findings of domestic violence pursuant to 18-6-800.3 and consistent with the agreement that's been reached. I'll place Mr. Snyder on a deferred judgment and sentence for a period of 18 months. Return date of January 7th, 2028. And again, Mr. Snyder, you don't have to appear on that date unless you've been notified. If everything's gone the way it's supposed to go, then a motion gets filed.
I was not mentally, emotionally, or physically prepared to hear about coming back in 2028, Judge. Not ready yet.
The court to please withdraw and case is closed. That's the end of the matter. However, if a motion does get filed at some point to revoke or to modify this deferred judgment, you would likely have to make a court appearance on that. I'll assess statutory fees and costs I have to assess for a Class 1 misdemeanor. And with that, anything further from the people?
Not from the people, Your Honor.
Anything from the defense?
Your Honor, we would just ask the court to honor the agreement. I think the court is pretty aware of the facts and the situation here. Although in the grand scheme of things, not a serious case, this is very serious for Mr. Snyder, and he takes it very, very seriously.
I would agree with that. It sounded like he took seriously every question. Yes, yes, Your Honor. Absolutely, Your Honor.
Really understands, and I've seen him grow in his understanding of how he should and can take responsibility for this and learn to treat his partners better. His partner is present in the room. I don't believe she wants to make a statement, but they have grown out of this ultimately and will continue to grow. And I know Mr. Snyder will as he continues treatment. The court will probably note that he has already completed a large portion of the domestic violence treatment and is doing well in that as well as in his private therapy. So we would ask to enforce the agreement. I have nothing more to add unless my client wants to make any statement.
Your Honor, I would just add that I accept responsibility for my actions. I know that no matter how I spin it, I was wrong to do what I did. I apologize to my partner, Courtney, to the court as well, and thank you for your time.
All right. Well, thank you, Mr. Snyder. I appreciate that, sir. Do you have any questions about the deferred judgment or how that works?
I do not, Your Honor.
Okay. Well, again, just make sure you have good communication with probation. Make sure they know how to get a hold of you and be proactive in addressing any issues or concerns you might be having so we can get you through this successfully. Okay.
Thank you.
All right. Stand by for some paperwork. We'll get you out of here. Take care. Picked up a little bit of momentum, didn't it?
All right, we're going to leave on that good note. We don't get many of those, mostly because they're just boring and I cut them out. But today we got one. Lawyer properly telling their client exactly what to say. The client understanding the assignment. We'll see if we get more of that in another 6 hours when we go live again. I'm guessing no. All right, guys. Thanks for coming out. I hope you guys have a great night. I'll see some of you again in a few hours. Thank you so much. See you guys.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed